Thank you very much, Peg. Good afternoon, everybody, and thank you for joining us today. My name is Richard Sitch. I'll be your moderator for today's DOL audit webinar. I'm President and Consulting Actuary here at Hooker & Holcomb. We're a leading regional firm specializing in retirement plan consulting for all types of employer-sponsored plans. I'm a fellow of the Society of Actuaries, fellow of the Conference of Consulting Actuaries, and enrolled actuary. I've been consulting on retirement plans for over 35 years. So every year, the Department of Labor and Internal Revenue Service perform hundreds of audits on employee benefit retirement plans. Even under the best conditions, these audits can be stressful and time-consuming for an employer. Today's webinar focuses on the DOL audit process and helping plan sponsors prepare should their plan be selected. So with us today, we have Marcia Wagner. Marcia is the founder of the Wagner Law Group, one of the nation's largest and most highly regarded law firms specializing in ERISA, employee benefits, and executive compensation. Marcia has practiced law for over 35 years and an authority on qualified and non-qualified plans, including DOL audits. So thank you, Marcia, for being here today. Also here is Derek Graves from Wolf & Company. Derek is a CPA and principal in Wolf's Assurance Group, and he leads the firm's employee benefit plan team. Derek has 20 years of experience providing audit services to privately held and publicly traded business. Derek is the firm's expert on DOL audits, and he often acts as a primary point of contact with the DOL for his clients during audits. So thank you, Derek, for joining us. We have Mark Condon from Hooker & Holcomb. Mark is vice president and practice leader of the firm's pension administration group. He's been in the retirement industry for over 30 years and is extremely knowledgeable about qualified and non-qualified defined benefit plans. Mark and his team are continuously improving plan administration best practices based on experiences with DOL audits and the latest DOL guidance. Before we begin, just a few housekeeping rules. So I make sure everybody is aware the session is being recorded and then may be posted to each firm's website for replay. Participants have been muted during the presentation. If you have any questions, please ask them in the chat section and address them to host. We'll answer as many questions as we can during the webinar. We're scheduled from 1 to 2. Questions will be answered at the end of the presentation. So with that, I will turn it over to Marcia.
Hello, good day, everybody. Let us begin. We have a lot to discuss. So let's start. Today, we will be providing you with a high-level view of Department of Labor audits with respect to tax-qualified plans, both defined contribution, such as 401k, and defined benefits, such as cash balance plans. We will be discussing how the subject matter of most DOL audits is determined, and also address steps that plan sponsors, you all, can take to reduce the risk of audit and to place yourselves in the best possible position in the event of an audit. With respect to the latter, we will be discussing cybersecurity, missing participants, timely movement of employee contribution and loan payments, and offering cryptocurrency as an investment option under the plan. Next slide, please. With respect to terminology, when an agency of the federal government conducts an audit, it is not looking solely to the financial operations of the entity, but also to its compliance with applicable law and regulations. Also, the Department of Labor is not the only federal governmental agency that conducts audits of tax-qualified plans. The Internal Revenue Service also conducts audits, although the focus is on whether the myriad requirements of Internal Revenue Code Section 401A are complied with. In contrast, a Department of Labor audit may have wider objectives. Its focus is on determining whether there have been any non-exempt prohibited transactions or breaches of fiduciary duty. A Department of Labor audit is intended to implement various enforcement priorities that the DOL has established. Among the issues that the DOL is currently focusing upon include late movements of elective deferrals, as I said before, missing participants as well, which Mark Condon will be speaking about in greater detail. Also, excessive fees to service providers, hard to value assets, cryptocurrency, cybersecurity issues, and ESOP valuations. Keep in mind, however, this list of topics is quite dynamic. If I were making a presentation such as this 2 years ago, I probably would not have included discussions of cyber security or cryptocurrency. And in that vein, future audits, I believe, might include questions for large plan sponsors regarding audited financials to determine whether the auditor is truly independent. You heard it here, folks. Finally, while it is possible in certain circumstances for a Department of Labor investigation to become criminal, we are only talking today about audits that are civil. If any of you are involved in criminal audits, please call me, frankly, immediately. Do not try that on your own. Next slide, please. ERISA Section 504C provides that in general, a plan should not be audited by the government more frequently than once every 12 months unless the DOL believes that there has been a violation of ERISA. As a practical matter, then, the Department of Labor really can and does audit whenever it wants. Also, as a practical matter, legal challenges to requests for documents by the DOL, particularly those requested by subpoena, are highly unlikely to prove successful, although, particularly for small businesses, the document requests of the DOL, including detailed payroll record information, can be quite burdensome. In terms of organizational structure, the Employee Benefit Security Administration, or EBSA, has a responsibility for ERISA enforcement. Its activity is primarily directed from the national office in DC, which identifies plan enforcement programs, provides enforcement guidance, and is responsible for the oversight of investigations. Next slide, please. Currently, there are 2 national priorities and 7 national enforcement projects. The 2 national priorities are major case enforcement and the Employee Contribution Initiative. The major case initiative represented a significant change in focus, with the DOL's attention directed toward service providers rather than individual plan sponsors. In contrast, the other initiative, the Employee Contribution Initiative, addresses a long-time concern of the Department of Labor, namely the timely movement of employee contributions. Consistent with this national priority, many of the documents and information requested in the initial document review may deal with payroll-related inquiries. Next slide, please. So each of these topics could be the subject of a webinar in and of itself. And those of you with ESOPs out there should be talking to your ERISA counsel. The audits are becoming very extreme, and I'm happy to speak to you as well. But for today's limited purposes, just for an overview of what the DOL is auditing, I'm just going to identify the priorities. The VFC program, the abandoned plan program, the contribution plan criminal project, the usually contributory defined benefit plans, plan investment conflicts, protecting benefits, health enforcement, and of course, ESOP is huge. Next slide, please. In addition to the DOL's national office, there are 10 regional offices and 5 sub-regional district offices. These offices carry out investigations authorized by the national office, but they're also semi-autonomous in nature, which is why occasionally a regional office will take a position on audit that is not shared by other regional offices and not even by the national office. In terms of resource allocation, attorneys in the regional offices deal not only with ERISA, but other federal statutes as well, such as the Family Medical Leave Act and mental health parity and substance abuse. Next slide, please. A fact sheet issued by the Department of Labor earlier this year indicates that in 2021, there were approximately 734,000 private retirement plans in this country, 2 million health plans, and 662,000 other welfare benefit arrangements. So if a plan sponsor were looking at the likelihood of being audited solely as a statistical matter, the likelihood of any tax qualified plan being audited by the Department of Labor in any particular year is small. However, to say the least, playing the audit lottery is not a recommended course of action, particularly with small businesses that might not have the wherewithal in general not to be in a position of complying with best practices on audit. Moreover, the Department of Labor has really increased its enforcement activities. For example, in 2021, fiscal year recoveries were approximately $2.5 billion, with $2.1 billion of that coming from civil enforcement activities, including $1.5 billion from missing plan participants. In addition to these monetary policies, the Department of Labor also obtained improvements in procedures and protocols in many of these circumstances, including the locating of missing participants. Next slide, please. By way of background, changing topics to another issue the Department of Labor cares about, for almost a decade, the Department of Labor has been asked to provide some type, anything, of guidance to plan fiduciaries and plan service providers concerning their responsibilities with respect to cybersecurity issues. In March of 2021, the Government Accounting Office report concluded that plan sponsors, record keepers, and others had little to go on as far as guidance from the DOL with respect to cybersecurity issues, and that it was not clear whether plan fiduciaries had a responsibility to minimize cyber risk. It recommended the GAO that the Department of Labor formally state whether it is a fiduciary responsibility to mitigate cybersecurity risks in defined contribution and defined benefit plans, and to establish minimum expectations for addressing cybersecurity risk in pension plans. Shortly thereafter, on April 14th, 2021, EBSA issued guidance in the form of 3 documents for best practices, one for plan sponsors and fiduciaries, one for plan service providers, and one for plan participants. For those looking for other relevant guidance on this important issue, shortly after the issuance of DOL guidance, the Spark Institute's Data Security Oversight Board announced its standards designed to protect retirement accounts from fraud. Next slide, please. What is surprising was the form in which the DOL provided the guidance. It was not done in the form of an advisory opinion or an information letter or a proposed regulation. Instead, it was basically just tips to interested parties. And there was no discussion of whether a participant's personally identifiable information was really a plan asset under ERISA. There was no discussion of the relative level of responsibilities of plan sponsors and fiduciaries. There was no discussion of whether state data breach laws are preempted by ERISA. And there was no clear statement of the prescribed measures for plan sponsors and fiduciaries to address cybersecurity issues. Next slide, please. Expressed somewhat differently, the guidance issued by the Department of Labor was prescriptive in nature rather than principles-based. If this guidance were to be challenged in district court, it would receive a very low level of judicial deference. It's called Skidmore deference for you techies out there, with respect to which a court will defer to an agency's guidance based upon its persuasiveness. Another fact that a court could take into account is the extent that cyber is outside of the DOL's area of expertise. Nonetheless, despite absence of real formal guidance, in the short time frame after issuance of this so-called guidance, the DOL requests information routinely about cybersecurity practices on plan audits. Next slide, please. For example, I just had an audit question where the DOL is requesting, and I quote, all documents relating to cybersecurity or information security programs that apply to the data of the plan, whether those programs are applied by the plan sponsor or by any service provider to the plan. More specific requests include policies, procedures, and guidelines to implement access control and identity management. The processes for business continuity, disaster recovery, incident response, cybersecurity awareness training, and encryption of sensitive information transmitted or secured. The DOL is also requesting all documents and communications regarding past cyber issues. So what I am encouraging my clients to do is adopt a cybersecurity policy, just like you have an investment policy statement or a fee policy statement. We provide this to our clients, and I think it's very important and perhaps protective. But it's a brave new world of cyber matters, and it will be interesting. And with that, I pass the baton to my colleague, Mark Condon. Mark?
Thank you, Marcia, and good afternoon, everyone. I'm going to focus on DOL missing participant guidance that was recently issued. Pension plan fiduciaries have an obligation to make sure their plan participants receive the benefits they are due in a timely fashion. There's been a renewed focus in this area in recent years, resulting in the DOL's Terminated Vested Participant Project, which started in 2017. The DOL's focus is on terminated vested participants and beneficiaries due a benefit who, for example, may have moved and not informed their employer of a new address, or may not be aware that they are even due a benefit, or they are deceased and the beneficiary is not aware that there is a potential death benefit due. And participants that are actually coming up against required minimum distribution rules, either age 70 and a half for participants that reached age 70 and a half prior to January 1 of 2020, or age 72 for all those thereafter. Next slide, please. I'm sorry, I have three points to make if you go back. So on January 12th, 2021, the DOL issued missing participant guidance. That was a long time coming. 3 pieces of guidance. The first is Compliance Assistance Release number 2021-01. The second is Best Practices for Pension Plans. And finally, Field Assistance Bulletin number 2021-01, which allows for the use of the PPGC's Missing Participants Program for terminating DC plans. We're going to focus primarily on the first 2 of these documents. Next slide. So the first of these documents is Compliance Assistance Release number 2021-01. And this is an important document for 2 reasons. One is that since it was released publicly, it gives plan fiduciaries special insight into the audit process and expectations of the DOL. The second reason it's important is it ensures some level of consistency for DOL audits across the country in terms of investigative processes and case closing practices. This document describes some of the information that will be required as part of an audit. And some of these items include plan documents, which also include summary plan descriptions or SPDs, census records, which also includes contact information, importantly, actuarial reports, which will have a summary of census information as well as summary of plan provisions, and then details of the action steps taken by plan sponsors to communicate with terminated vested participants and to address missing participants in general. Some of the errors that they investigate as part of the audit include systemic errors in record keeping. For example, if there are large numbers of missing or incomplete data, such as social security numbers or dates of birth. And then inadequate procedures for identifying and locating missing participants, contacting terminated vested participants approaching normal retirement age, contacting terminated vested participants approaching required minimum distribution age, age 72, as I mentioned, and then addressing what to do about uncashed checks. It's important to note the ultimate goal of the DOL is not to be punitive, but to facilitate voluntary compliance efforts by plan fiduciaries. Next slide, please. The second document, which is where I'm going to spend most of my time is the best practices for pension plans. It's geared towards plan fiduciaries directly, and it's part of the EBSA initiative to help plan fiduciaries ensure that participants receive the benefits they are due. This document starts by describing red flags that may identify potential problems, such as the existence of more than a small number of missing or non-responsive participants, more than a small number of terminated vested participants at normal retirement age who have not yet begun to receive benefits, missing, inaccurate, or incomplete contact information and census data, a lack of sound policies for handling undeliverable or returned mail, a lack of sound policies for handling uncashed checks. The DOL notes that plans with the lowest number of missing and non-responsive participants are those that make a commitment to keeping plan records complete and are proactive in taking steps to ensure benefits are paid when due. Next slide. So there are four areas that the best practices document identifies as key areas of best practices. The four are: one is maintaining accurate census information. The second is implementing effective communication strategies. The third is running frequent missing participant searches. And then fourth is documenting procedures and actions. And we're going to cover each of these on the following slides. Next slide, please. So the first of these is maintaining accurate census information. Some examples of best practices here would be contacting current and former employees regularly to keep contact information up to date, and beneficiary information as well. Flagging undeliverable mail and uncashed checks. Providing opportunities for participants to provide updated information, for example, by providing access to contact information change forms or an online platform where they can actually type in the information themselves. A best practice includes conducting regular audits of census information. When there's a transfer of data to a new record keeper, conducting missing participant searches of employer records is important as well. And as an example of that would be some of the missing information may be found by cross-referencing against items like payroll records or other plan records like employee health plans. Next slide, please. The second area of best practices is implementing effective communication strategies. Using plain language and explanations of plan benefits and offering non-English assistance is helpful. Encouraging contact through plan sponsor websites and toll-free phone numbers. So there's a kind of a two-way communication going on between the participant and plan sponsor. Building in steps during both enrollment and exit processes to ensure that all information is complete and up to date. That includes beneficiary information, contact information, etc. And then finally, using employer marked envelopes in mailings to participants. Participants are more likely to open the envelope if it is from a former employer as opposed to from some new record keeper that they may not be aware of. Next slide, please. The third area of best practices is running frequent missing participant searches. So this would include things like checking related plan and employer records for participant and beneficiary information, as I mentioned before, cross-referencing against payroll and other benefit plans such as health plans. Checking with designated beneficiaries and emergency contacts. Using free online search engines, public records databases, obituaries, and social media. Using commercial locator services and death searches. Using USPS certified mail. Reaching out to former colleagues That's actually a very effective way of finding people that may have moved and gone away. That there's often people that keep in contact with each other, and that's a good way to track someone down that's due a benefit. Also registering missing participants on public and private pension registries, for example, the National Registry of Unclaimed Retirement Benefits. And importantly, repeating these steps frequently. It's not just do it once and forget about it. It's really a good practice to do this, say, once a year and kind of clean up the records that way. Next slide, please. And then finally, the fourth area of best practices is documenting procedures and actions. So putting your procedures in writing, documenting how you arrived at the decisions and implementation steps that were taken. And then also ensuring that your third-party record keepers are performing the services they agreed to. For example, regular death searches and providing evidence of that and the results of those searches. So to close this out, the DOL states that this guidance does not have the force and effect of law, but rather is intended to provide clarity to the public regarding existing requirements under the law or DOL policies. And with that, I will turn it over to Derek. Thank you.
Thanks, Mark, and thanks everybody for joining us today. I'm Derek Graves, a principal in Wolf & Company's audit team, and I'll be covering a couple of topics today, the first being late deposits of elective deferrals and loan repayments, and also crypto as an investment option within your 401k plan. So we'll start off with the late deposits. And as many of you know, one of the Department of Labor's hot button issues for many years has been late deposits of participant deferrals in loan repayments. If you've been lucky enough to be selected by the IRS or the Department of Labor to have your plan examined, you know that they're going to be inquiring about controls and processes as it relates to remitting participant contributions and loan repayments, and also a lot of your payroll controls as well. I'll provide a few best practices, but before we get to that, a little bit of background on the context of late deposits. The Department of Labor does consider participant contributions to be plan assets. Therefore, they must be deposited to the plan as soon as administratively feasible, once amounts can be reasonably segregated from the plan sponsor's general assets. So when are participant contributions and loan repayments required to be deposited into the plan? Well, there's two sets of rules, one for small plans, those with fewer than 100 participants in your plan, required to deposit those participant contributions into the plan no later than the 7th business day following the pay date. For all other plans, participant contributions are required to be deposited on the 15th business day following the pay date. However, that 15-day rule is not a safe harbor. Technology has changed and improved significantly over the years, so therefore it's impacting the way payroll is processed. So the DOL's expectation is that if an employer can determine the payroll taxes and other withholdings and remit those amounts on the same day of payroll, the employer can also determine the amount of the participant contributions and remit those on the pay date as well. So what happens if the plan has late deposits during the year? Well, as I mentioned, since participant contributions are considered to be plan assets by the Department of Labor, if they are not timely deposited, it is considered to be a prohibited transaction, which is a transaction between a plan or disqualified person, that disqualified person being the employer, in which the law prohibits. It's as if the plan is providing a loan to the plan sponsor. A disqualified person, or the employer in this case, who participated in a prohibited transaction must correct this and pay an excise tax. And that initial tax is 15% of the amount of the late deposit. A couple other things in regards to reporting any late deposits, that if you're a large plan and you have late deposits, you're required to report the late deposits on Form 5500, Schedule H, line 4A, by checking yes and entering the dollar amount of the late deposit into the form. If you're a small plan, those with 100 or fewer participants, and file a Form 5500 SF, that's completed on Part 5 of that form. Now, if you want to fully correct those late deposits, of course, you need to remit those participant contributions and loan repayments that were late to the plan. But you also must calculate and remit any lost earnings on those late deposits. And the IRS and DOL have great calculators out there to help you determine what those amounts would be. Those late deposits, of course, are required to be presented on the Form 5500 until the year following the amounts have been fully corrected. The IRS also has a great fix-it guide for late deposits And if you would like to get a link to that, feel free to reach out to any of the presenters. To fix the mistake, you can correct this through the Department of Labor's Voluntary Fiduciary Correction Program, which Marcia had mentioned earlier. And then in order to do so, you must deposit, of course, all of those late deferrals in any lost earnings as a result of those late deposits. Now, a few tips on how to avoid the mistake. You should establish procedures requiring elected deferrals to be deposited coincident with or after each of your payroll per your plan document if the plan document specifies as such. If deferral deposits are late because of individuals being on vacation or other disruptions, make sure you keep a record of why those deposits were late. Another best tip is to make sure you coordinate with your payroll provider to determine the earliest date that you can reasonably make those deposits, and then set up procedures to ensure that you're making those deposits by that date. And then, of course, you should have documented and implemented practices and procedures that you explain to new personnel as turnover occurs to ensure that they know when the deposits should be made. As auditors, we communicate the importance of timely deposits with our clients, and we actually provide them a template to help them document and assist in ensuring that deposits are made timely. And that template documents and supports the controls in place to monitor the date amounts are remitted to the plan. It includes items such as pay dates amounts were deposited at the TPA, participant contribution amounts, and loan repayment amounts. The template will help you calculate the number of days between the deposit date and the pay date for each pay date during the plan year. And the template also calculates an average of the number of business days between the deposit date and your pay date. That average is then compared to the number of days until deposited and will flag anything that is irregular that you should be investigating further, and allows you to document right in that form as to the reasons why. It could be vacations or whatnot. And again, if you would like a copy of that template, feel free to reach out after the webinar. Next slide, please. The next topic I'll cover is crypto as an asset in 401k plans. The Department of Labor had issued a compliance assistant release back in March of 2022 regarding crypto as an investment in 401k plans. The release addressed concerns by the Department of Labor regarding 401k plans that are offering crypto and digital assets as investment options. I'm not aware of any plans that we currently work with that have crypto or digital assets as investment options within their plan. And the DOL released this because they saw an uptick in awareness of firms marketing investments in crypto and digital assets to 401k plans as potential investment options. The release by the DOL cautions plan fiduciaries to exercise care before adding such investments to a plan's investment menu for plan participants. Under ERISA, fiduciaries must act solely in the financial interest of plan participants and adhere to an exacting standard of professional care. Any fiduciary who breaches those duties is personally liable for any losses to the plan resulting from that breach. A fiduciary consideration of whether to include an option for participants to invest in crypto or digital assets is subject to the responsibilities of professional care. And fiduciaries have an obligation to ensure the prudence of those options on an ongoing basis. A fiduciary may not shift the responsibility to plan participants to identify and avoid imprudent investment options, but must rather evaluate the designated investment options to ensure that they are prudent. Next slide, please. The DOL in the release expressed some serious concerns about the prudence of fiduciary's decision to expose a 401k plan's participant to direct investments in crypto. These investments, according to the release, present significant risks and challenges to participants' retirement accounts, including significant risk of fraud, theft, and loss for all of the following reasons: the speculative and volatile nature of those investments, the challenge for plan participants to make informed investment decisions, custody and record-keeping concerns, valuation concerns in the regulatory environment. The SEC staff has also cautioned that investment in crypto is highly speculative. Cryptos have been subject to extreme price volatility, and that volatility can have a devastating impact on participants, especially those approaching retirement. Crypto is often promoted as an innovative investment that offers the potential for huge profits. These investments can all too easily attract plan participants with great expectations of those high returns, but little appreciation for the risk that's posed. Crypto is not held like traditional plan assets in trust or custodial accounts, not readily valued, and not available to pay benefits and plan expenses. Instead, they generally exist as lines of computer code in the digital wallet. With some crypto, simply losing or forgetting a password can result in the loss of the asset forever. Other methods of holding crypto can be vulnerable to hackers and theft. The DOL in the release expressed concern about the reliability and accuracy of valuation of crypto as well in digital assets. Experts have fundamental disagreements about important aspects of the crypto market, noting that none of the proposed models for valuing crypto are as sound as traditional equity and debt markets. The other piece is that rules and regulations governing crypto markets may be evolving, and some market participants may be operating outside of the existing regulatory framework or not complying with them at all. Next slide, please. So what's next for the DOL? The Employee Benefit Security Administration expects to conduct an investigative program aimed at plans that offer participant investments in crypto and related products, and to take appropriate action to protect the interests of plan participants and beneficiaries with respect to these investments. And with that, I'll send it back over to the moderator, Rich, for any questions.
Thank you very much, Derek. We do have some questions that came in, so I'm going to try to direct them to the person that they were directed to. So I think this is for Marcia. The question is, they have a client or a company has an administrative services agreement where the plan's record keeper provides a low dollar amount capping its liability for any breaches of the agreement, which would include cybersecurity breaches. Is that permissible under ERISA? And if so, as a practical matter, if my plan is a small or mid-sized plan, what is my recourse?
That's a facts and circumstances determination. And so what you have to do is you have to see what is the cap in relation to the potential liability, how big is the plan, how the record keeper has performed in the past, et cetera. This is an issue the Department of Labor has struggled with, and the determination as to whether or not to hire and retain any service provider, record keeper or not, with a cap is a fiduciary determination. And you really do have to weigh the factors. How low is the cap? How high or low is the fee? Will a higher fee give a higher cap? I mean, what is the history? What is reasonable? And I would say you would be well advised to run whatever decision you're going to make through your advisor or through a risk counsel to determine what is fiduciarily prudent.
Okay, thank you very much, Marcia. We have another question for you.
Great.
Generally, when the DOL provides guidance, it speaks in terms of fiduciary duties, but guidance with respect to cybersecurity was labeled best practices. Other than in a litigation context, is that distinction relevant?
That's an excellent question. Legally, there's no such thing as a best practice, period. There's a fiduciary obligation under ERISA section 404 to be reasonably prudent, but there's no requirement to comply with best practices. Having stated that, however, once the government lets you know what it considers its best practices concerning something of a fiduciary matter, it is extraordinarily important that you take that seriously. Because even though the type of deference, as I said, would be low with respect to if there were a challenge to this quote unquote guidance, nonetheless, the issue is out there, and a fiduciary who is prudent will be aware that cyber matters are important, which is why I think a cyber policy statement is probably at least somewhat prophylactic. So I would say that the law is a dynamic creature. As our society evolves, you will see best practices becoming standard, becoming law. So I would say we are very much on the tip of that type of change. And it's always better to be ahead of the curve than behind it, especially for small employers.
Very good. Thank you, Marcia.
You're welcome.
This looks like a question for Mark. Are plan fiduciaries required to implement all of the DOL best practices in the guidance?
Yeah, that's a great question. Not necessarily, not every single one of them. Again, it's facts and circumstances that apply to your plan and your situation. Certainly, these are guidelines that, again, they mentioned will result in better results than what you may have had in the past. And again, they're trying to get plan sponsors to take on and own up to their fiduciary responsibilities. So you do what you need to do to get as many people found as possible, and keep repeating them and documenting them. And those are, again, best practices. That doesn't necessarily mean you have to implement every single one of them, but if you're not having success with one step, you should try others. So I think it's wise to kind of take them all seriously, but they're not necessarily hard and fast requirements.
All right, thank you, Mark. One more question for you here. Is there a bright line test for determining whether a problem exists?
No, there's not. They use language like more than a small number of this, more than a small number of that. They don't define what those small numbers are. So they are looking for widespread issues of things like you've got a number of terminated vested participants that are past age 65 that have not been put into pay status. So they're looking for those kinds of things. There's no bright line test that necessarily says if it's more than 10 or less than 10. So just be aware of that. You're always going to have potential for one or two that you just can't find despite best efforts. But they're really focused on the plan sponsors that have largely ignored it, and trying to get them to increase their awareness of it, increase their best practices around that, and to find those people, make a concerted effort to find those people.
Okay, great. Thank you, Mark. Marcia, another question for you. A participant's account is hacked and it was not the fault of the plan administrator or plan sponsor. Do either of them have a responsibility for making the participant whole?
About 30 years ago, in the early days of my practicing of law, I realized there was a real issue with the non-transparency of fees. And I predicted, but no one listened to me, the advent of all the 401k fee lawsuits, because that which can't continue, frankly, won't. Which, by the way, you'll see in the welfare benefit area soon enough. There will be a time when the IBM pension plan is hacked or some small pension plan is hacked somehow and assets are dissipated. Now, let's assume it's faultless. It's not the plan administrator's fault. I mean, that's going to be a tough scenario. We're having some court cases now that's trying to ascribe blame to a record keeper that didn't have appropriate cyber matters. We're starting to see settlements where a plan participant really did not behave appropriately with respect to their personal identifiable information. So there was the attempt to ascribe blame, but no amount of blame, in my opinion, can justify the wiping out of someone's account. So the question is, quite frankly, who holds the bag? Plan sponsor, record keeper, custodian, plan participant, all of the above, in what proportion? I think that there's going to be a lot of nasty and ugly cases that are going to come up. And what I'm hoping for, and what I've spoken about, and what I don't know how to get past as legislation, is something akin to the PBGC for cyber matters. I'm sorry. For those of you who don't know, the Pension Benefit Guaranty Corporation is effectively the FDIC to fund the pension plans, overly simplistically. We need something like that because people are going to be hacked, and I don't know when it will occur, but sometime within our lifetimes, but not that far out, there will be a massive hack of a pension plan or a pension system. And we're going to have to confront this. Does our society make these people whole? Should there be mandatory insurance? What if something is uninsurable, like property in Florida? What do we do? And these are questions that I think are extraordinarily important to raise, So I've been squawking up and down that we need something to protect plan participants beyond, some small employers' ability to negotiate a good insurance policy or a good contract with a record keeper, and that the record keeper actually has the ability to have good cyber. It's a tough question. It's one that our society is going to have to face forthrightly, or I fear the litigation will become fast, furious. And if you think 401k fees were bad, you ain't seen nothing yet. So that's what I'm hoping. I'm hoping we can get ahead of this. And I hope that our government takes responsibility for an issue that I don't think any reasonable, I'm not talking about unreasonable protocols, but any reasonable plan participant, beneficiary, alternate payee, service provider, or fiduciary really couldn't insure against.
Okay, great. Thank you, Marcia. Derek, is there a de minimis exception for lost earnings on late deposits?
Good question, Rich. We hear about this a lot when I attend the AICPA National Conference on Employee Benefit Plans, and the DOL is there, the IRS is there, and they've always mentioned that there is really no de minimis amount. So unfortunately, there is really no out for a de minimis amount as far as when you're calculating lost earnings or if there's late deposits and things like that. So unfortunately, you need to report them and get them corrected accurately, so that if the IRS or the DOL comes knocking on your door for an audit, you are covered in that respect.
Okay, great. One more question for you, Derek. If employee contributions and loan repayments are not processed timely, aside from presenting an issue on a DOL audit, are there other sanctions?
Yes, there could be, since it is a prohibited transaction. I think that Marcia touched upon earlier too in her presentation, but yes, there could be some penalties that are imposed to the individuals.
Okay. This may be a question for Marcia and or Mark. I'll let Marcia chime in first. Does the responsibility for keeping track of plan participants extend to their beneficiaries as well?
Yes.
Agreed.
Okay, 2 yeses. Missing participants again. With respect to missing participants, to what extent can responsibility be placed on plan participants to keep the plan sponsor and or administrator informed on changes in location?
I think it's a partnership. I think that, I'm sorry, was that for me?
Oh, you can go ahead.
I think that there's a concept in law known as contributory negligence. So, I mean, if a plan participant knows that he is moving on, or the address has changed, or his email's changed, there is a responsibility that he inform the plan sponsor or the record keeper, or both preferably. However, if the plan sponsor or the record keeper notices that nothing's opened up ever, that there is a duality of responsibility as well. And again, I hate to keep on coming back to facts and circumstances, but as the employer, it really is your responsibility to keep very good records as to who gets a benefit, where they are, what is their distribution dates, their vesting status, et cetera. That is clear. The question is, to what degree does the plan participant have responsibility? He does have some responsibility, but will it inoculate a plan sponsor from not having to find a missing plan participant, or not pay a benefit, or not try to find them? No, there is no inoculation for that.
Yeah, I would agree with that. I think of the example of a participant that is really unaware that he even has a benefit due, and that doesn't absolve the plan sponsor from just saying, okay, he doesn't know, he didn't come forward, so forget about him. There's still an obligation. And again, the best practices kind of walk you through. Here are things you need to try to do to find that participant. If you go through that list and that person just you did everything you could and never turns up, well, there's not much you can do about that, but you've got to kind of go through the effort as well as a plan sponsor.
Okay, thank you, Marcia. Thank you, Mark. We do have a question that came in through the chat. In the event of a DC plan termination, may an unresponsive participant be considered a missing participant, where the plan sponsor can turn over their account value to the PBGC?
No, there's a whole process you have to go through. and steps you have to go through before assets can be sheeted to the state or turned over. So I would say, just because he's non-responsive 1 or 2 times, you have to really define non-responsive and what efforts were made to locate him or her.
Yeah, and in my presentation, I mentioned 3 documents that the PBGC, I'm sorry, the DOL issued, and the third of those is the one that I didn't really cover much, but it does talk about a procedure for using the PBGC missing participants program for terminating DC plans. So there is some guidance in there on how that can be used as well.
Okay, great, thank you. Starting to run out of time, so let me just throw out one more question. And this is either for Marcia and or Derek. In determining whether employee contributions are segregated from plan assets as soon as reasonably practicable, is that determination made on an average time period basis or on a payroll by payroll basis?
I think it's done. I'll take it first, Derek, but you look at the averages, what has been done prior. And if something could be done within a certain period of time, then usually it's even lesser, not the average, but the least period of time that something's been done with respect to withholding would be the period of time on audit the Department of Labor would look at. Now you can push back against that and push it off a little bit from what had historically been done. But the Department of Labor is going to is going to want as soon as reasonably practicable. And I usually say that's a 1 to 2 day time frame, even for a small employer, because most small employers use payroll providers such as a Paychex or an ADP or a Velocity, and it effectively can be done very, very, very quickly. If for whatever reason payroll is still being done by hand, internal to the organization, I would say that the department, from my experience with audit, almost always looks at the average lower period of time that segregation has occurred in the past.
I would agree with that as well, Marcia. As auditors, we look at it on a payroll by payroll basis, of course, factoring in kind of the average. But as you mentioned, with the ADPs and Paychex and everybody else out there, it's usually a day or 2, or sometimes it's even the day before the pay date.
That's true.
We're looking for that consistent pattern. And then, of course, if there's anything outside of that pattern, we make sure we investigate a little bit further and discuss with them as to whether or not it should be reportable.
All right, thank you very much, Derek. Thank you, Marcia. So we're kind of running out of time here, so I think we should probably wrap it up. So that will conclude today's webinar. So thank you very much, everybody, for attending. We hope you found the information useful. I do want to thank our presenters, Marcia, Derek, and Mark, for taking their time to go through and pull this information together. Certainly, if you have any questions, feel free to reach out to anybody. The contact information is early in the presentation. Feel free to shoot them an email or give them a call and get your questions answered. So thank you very much, everybody, and enjoy the rest of the afternoon.